Okay. So when filing a trademark application in China, there are several common procedures that may arise during prosecution. Prosecution. Sorry. Let's take a quick look at what to expect. So when filing a trademark application in China, it is very, very common to receive a provisional refusal, especially when your application shares similarities with early filings. This is due to China's strict relative grounds examination. But a refusal isn't just the end of the road. Applicants can always file a review with the Trademark Review and Adjudication Board. You can consider it as a review office of the Trademark Office. But a review must be done within 15 days of receiving the refusal notice. For online filings, there is an extra 15-day grace period to account for postal time. So in general, it's quite a short period. We have to at least file a formal petition stating that we have the intention of arguing this case and continued with our application. And then we have a 3 months window to supplement our argumentations and evidence if we have any. So the Trademark Review Board typically issued the decision within 9 months after the review is accepted. Also, in some cases, if you initiate adversary actions against the citation, the site marked, such as non-use cancellation or invalidation, the Trademark Office will typically agree to suspend the review process while those adversary actions are pending. This is a case-by-case scenario, but nowadays, typically the Trademark Office will accept the suspension, will stay the case. Okay. So as we mentioned, it is quite common to receive a provisional refusal, especially due to signed prior rights. One question clients often raise is, can we just get a coexistent consent letter from the site mark owner and move forward? It used to work for some cases, but now, unfortunately, the coexistent consent letter is rarely accepted in administrative level. Even the applicant appeal the case to court, the court may accept some in some cases, but not always. So you better be assume that a coexistent consent will not work well here in China, and that's also says the importance of a pre-filing clearance search. A good search can flag potential conflicts early, allowing us to assess whether it is worth proceeding or we need to adjust our application, or perhaps targeting different goods or services to be able to distinguish from the located early rights. When a conflict is identified, we usually suggest clients to explore viable strategies, whether it is filing a non-use cancellation or negotiating a purchase assignment with the prior trademark owner, or preparing our relatively strong argument for dissimilarity in anticipation of a provisional review. So the goal here is to reduce surprise and give the application the best chance of success from the start. Now let's take a look at a very common procedure that we encounter during trademark prosecution, which is non-use cancellation. It's a very common and strategic tool for clearing obstacles during trademark prosecution. So under Chinese law, any entity or individual can file a non-use cancellation request. But before filing, a relatively thorough in-use investigation is required. If that investigation clearly reveals signs of use, we as agent may not be in a very good position to proceed with the non-use cancellation. This is from an ethical and a procedural consideration. Since early this year, I mean 2025, there's been a tightening trend around non-use cancellation. Applicants now face added responsibilities. They must affirm that they're acting in good faith, disclose all relevant facts, and confirm that they are not using a shell entity or hide their true identity. This is part of the Chinese Trademark Office way of curbing malicious filing made through intermediaries. Because in the past, there may be some bad faith filer who file non-use cancellations against one specific trademark for many, many times. Because raising a non-use cancellation is inexpensive at all, but for the trademark owner who must file a full defending argument against this non-use cancellation is costly. So if the trademark owner face multiple non-use cancellation requests, it can be quite challenging for the trademark owner to handle it. That's the case. When you file a non-use cancellation, it is also now mandatory to disclose the related matters, such as if you file a non-use cancellation because your trademark application is blocked by this application, you have to show, you have to tell the trademark office the related trademark proceedings. Yeah. So in today's environment, a successful non-use cancellation requires not just diligence, but also transparency and strategic planning. Filing without proper groundwork doesn't just risk failure, it could raise flags for bad faith conduct. So in terms of timeline and procedures, the Chinese Trademark Office typically issue a decision within 12 months of receiving a non-use cancellation request. Although this may vary slightly depending on the complexity of the case, either party, after receiving the decision, if any party disagrees with the decision, they can appeal the decision to the next level, which is also within the administrative structure. And if you still don't satisfy with that decision, you may also appeal the case to IP court. Another common procedure that we come across very often is opposition. For foreign brand owners, we usually act as opponent. So firstly, let's talk about timing. If you want to file a trademark opposition, it has to be filed within 3 months of the trademark preliminary publication. Here's the thing. Let me briefly touch on the trademark filing procedure here in China. So firstly, you filed your application, and then the application got formally examined and substantively examined. And then if the application passed the substantive examination, it will get to preliminary approved for 3 months, simply for opposition. If no opposition is received within this 3 months, the application will mature to registration. So here's the thing. The opposition window is 3 months, and it cannot be extended. You have to file your basic grounds and argumentation within this 3 months. And after that, another 3 months window will be provided for supplementing evidence and argumentation. So as for opposition, opposition may be based on relative grounds such as earlier trademarks or absolute grounds like misleading elements, public interest concerns, or lack of distinctiveness, and so on. So once the opposition is filed, the Chinese Trademark Office will examine arguments from both sides, and a decision is typically issued within 12 months. Sometimes it can take longer, but typically they don't extend beyond 18 months. If the opposition succeeds, meaning the application is rejected, then the trademark owner may seek a review on the administrative level. On the other hand, if the opposition fails, meaning the application will proceed to registration, there is no appeal route for the opponent, but the opponent may consider filing an invalidation of the registration, which functions exactly like a post-grant opposition. Okay. Well, we just mentioned invalidation. Actually, it's a function as a post-grant opposition, and the grounds applied for invalidation, it's largely the same as that for opposition. So let's take a look at the timing. If you're acting on relative grounds like prior rights, you have 5 years from the date of registration of the target trademark to file an invalidation. If you're acting on relative grounds, of course, you have to be an interested party. But if you act on absolute grounds, such as bad faith, public order issues, or lack of distinctiveness, there is no time limit. Anyone can file an invalidation. Just like I mentioned, as opposition and invalidation typically follow the same timeline. It's around 12 to 18 months for the trademark office to issue a decision. The decision can be appealed, but cannot be appealed on an administrative level. It has to be appealed to the court. So here is the difference from opposition. So here I made a side-by-side comparison chart between trademark opposition and invalidation. Actually, they have shares a lot in common, but they also have their own differences. For example, the target opposition applies to marks that are still in the publication stage, meaning not yet registered. But for invalidation, we're talking about already registered trademarks. And the timing is also different. If you want to file an opposition, it has to file within 3 months of the publication day. However, if you are aiming to file an invalidation, you have longer, you have a bigger window, simply bigger window. You can find an invalidation within 5 years of the registration day of that target trademark. As for procedures, opposition doesn't involve cross-examination. It's based on written arguments. Simply, you don't get the chance to challenge the other side's material. You have the chance to view the other side's material and file one counter argument, and that's it. But for invalidation, cross-examination is allowed. But of course, that's only available after the trademark owner files a defense. So that's the second part of my presentation that covers mainly the most common seen procedures that we may encounter during trademark prosecution.